Good afternoon. Welcome to the latest Doughty Street webinar. Following last week's webinar on contributory negligence, Chris Johnson, Freddie Powell and I, Nick Brown, are going to talk about vicarious liability following the recent Barclays and Morrisons cases in the Supreme Court. The plan is to keep it short and snappy. Chris, Freddie and I intend to talk for only about 40 or 45 minutes. I will talk briefly about the general principles. Chris and Freddie will talk in more detail about the application of those general principles in individual situations and cases. But there will be time for questions at the end. Please use the question and answer icon at the bottom of your screen if you want to ask a question. So let's start. The two key questions in answering whether one person is vicariously liable for the torts of another are: one, what is the relationship between the defendant and the tortfeasor? Or to be more specific, is it such a relationship which makes it proper in law for the defendant to pay for the wrongdoing or fault of the tortfeasor? The second key question is, what is the connection between this relationship and the tortfeasor's wrongdoing? Or again, to be more specific, is the connection between this employment relationship akin to employment, and the tortfeasor's wrongdoing sufficiently close to make it proper in law for the defendant to pay for the wrongdoing or fault of the tortfeasor? As I've just said, the proper approach as to how to answer each of these two questions has recently been considered by the Supreme Court in two cases, Barclays Bank case and the Morrisons case, respectively. The two questions, separate questions, must be answered independently of one another. Dealing with the first issue first, what is the necessary relationship between a defendant and a tortfeasor to give rise to vicarious liability? Following the Barclays Bank case, the approach to answering the first question is now probably a lot more simple than many of us previously thought it was. You have to examine the details of the relationship between the defendant and the tortfeasor and ask yourself whether, judged objectively, the tortfeasor is an employee of the defendant or in a relationship akin to employment with the defendant, or whether, on the other hand, the tortfeasor is carrying on business on his own account and therefore an independent contractor. Now, in the vast majority of cases, the answers will be reasonably straightforward. The tortfeasor will clearly be an employee of the defendant, or the tortfeasor will be in business on his own account. If the former, vicarious liability attaches. If the latter, no vicarious liability attaches. This is because, to cite Lord Bridge in the DNF Estates case, it is trike law that the employer of an independent contractor is in general not liable for the negligence or other tort committed by the contractor in the course of the execution of the work. On the facts of the Barclays Bank case, the answer was clear. Dr. Bates, the doctor who had allegedly sexually assaulted the numerous job applicants who had been referred to him by Barclays Bank so that he could carry out a medical examination of them before the bank employed them, was clearly in business on his own account. Doing medical examinations and preparing these reports on behalf of Barclays Bank was a relatively minor part of Dr. Bates's practice. He also worked as an employee in local hospitals, and he carried out medical examinations for a variety of different organisations and for a number of different purposes. He was therefore clearly in business on his own account and an independent contractor. Barclays Bank was therefore clearly not liable for his wrongdoing. So far, so simple. But how should you approach the difficult cases and decide on which side of the dividing line any particular case might fall? The short answer is now to ask yourself this. Looking at the details of this particular relationship, is the essence of the relationship between the defendant and the tortfeasor truly one akin to employment? Or are the wrongdoers in truth independent contractors? Put it another way, is the relationship closer to that of an employer and employee, or closer to that of an employer and an independent contractor? In E's case, in 2013, Lord Justice Ward summed up the difference between an employee and an independent contractor in these terms at paragraph 70. An employee is one who is paid a wage or salary to work under some, if only slight, control of his employer, in his employer's business, for his employer's business. The independent contractor works in and for his own business, his risk of profit or loss. As Lady Hale points out in the Barclays Bank case, the consistent thread running through all of the main decided cases in which the court has held that the relationship between the defendant and the tortfeasor was a relationship akin to employment is that it could not be said that the tortfeasor was in business for himself. So in the Christian Brothers case, it could not be said that the brothers who were teachers at a residential school and who had allegedly physically and sexually abused their pupils were independently in business on their own account. In Cox and the Ministry of Justice, the prisoner who injured the prison catering manager whilst working under her direction on prison service pay could not be said to be independently in business on his own account. Finally, as Lady Hale emphasised, the key feature in Arms and Nottinghamshire County Council was that the foster parents who had allegedly physically and sexually abused the claimant cannot be regarded as carrying on an independent business of their own. Therefore, the key issue which you will need to focus on is whether it can truly be said that the relevant relationship was, in its essence, an employer-employee relationship, or whether, in truth, the tortfeasor was carrying out an independent business on his own account. It is only in doubtful cases that the 5 policy reasons identified by Lord Phillips in the Christian Brothers case, and which was so much the focus of Lord Reed's judgment in Cobb, may, and I emphasise Lady Hale's use of the word may in paragraph 27 of the judgment in the Barclays Bank case, may be helpful in deciding on which side of the line a particular relationship falls. Clearly, those cases will be rare, and in any event, they are only policy reasons, and they should not be elided into points of legal principle. In short, the more expansive policy-led analysis of whether a particular relationship is akin to employment suggested by the judgment of Lord Phillips and Christian Brothers and Lord Reed in Cox has, for most practical purposes, been relegated to history. Turning now to the second issue. In the Morrisons case, there was no question of the tortfeasor being other than an employee of Morrisons at the relevant time. The key issue was the second question. Was the connection between this employment relationship and the tortfeasor's wrongdoing sufficiently close to make it proper in law for the defendant to pay for the wrongdoing or fault tortfeasor? Again, in most cases, this will not be a live issue. There's clearly a sufficient connection when the lorry driver making a delivery collides with a motorcyclist, or an appropriate guard has not been placed on a cutting machine in a factory. But what are the boundaries of the connection between an employment relationship and a tortfeasor's wrongdoing, beyond which the employer is not liable for the torts of his employee? In Morrisons, Lord Reed confirmed that the correct legal test was the test laid down by Lord Nichols in Dubai Aluminium, paragraph 23. Namely, the question is whether the wrongful conduct was so closely connected with the acts the employee was authorised to do that the purposes of the life of the employer to third parties, the wrongful conduct may fairly and properly be regarded as done by him while acting in the ordinary course of his employment. What does that mean in practice? Lord Nichols went on to say in Dubai Aluminium at paragraphs 25 and 26, this test affords no guidance on the type or degree of connection which will normally be regarded as sufficiently close to prompt the legal conclusion that the risk of the wrongful act occurring and any loss flowing from the wrongful act should fall on the employer rather than the third party who was wrong. This lack of precision is inevitable, given the infinite range of circumstances where the issue arises. What was Lord Reed's solution in Morrisons? He said, the general principle set out by Lord Nichols in Dubai Aluminium, like many other principles of the law of tort, has to be applied with regard to the circumstances of the case before the court and the assistance provided by previous court decisions. In other words, many cases will turn on their precise facts, but you should look to other decided cases in comparable situations to identify, or should I say to try to identify, from sometimes apparently inconsistent decisions, the factors and principles which point towards or away from vicarious liability in your own individual case. To finish, I just want to highlight two of the principles which emerge from some of the decided cases. First, in most situations, the key distinction which will be made will be between one, circumstances in which, however misguidedly, an employee can be said to be engaged in furthering his employer's business. Two, circumstances in which an employee can be said to be engaged in an independent venture of his own, or to use the old language, be on a frolic of his own. So in Morrisons, the case concerned an internal auditor who had a grudge against the company, who clandestinely published personal information concerning thousands of Morrisons employees and former employees, part of a vendetta against Morrisons, his employers. Perhaps unsurprisingly, the Supreme Court decided that the former employee was on a frolic of his own, and that the company were not vicariously liable for behaviour designed specifically to harm themselves. By contrast, Mohammed and Morrisons, the 2016 Supreme Court case, the case in which a petrol station attendant had assaulted a motorist after ordering him to leave the petrol station using threatening and racist language. In that case, the claimant was able to establish vicarious liability because, however appallingly he had behaved, the petrol station attendant was purporting to act throughout as an employee in the furtherance of his employer's business. Lord Toulson said in his judgment at paragraph 47, this was not something personal between them. It was an order to keep away from his employer's premises, keep reinforced by violence. In giving such an order, he was purporting to act about his employer's business. It was a gross abuse of his position, but it was in connection with the business in which he was employed to serve customers. The second principle, which I want to highlight, is that, as Lord Reid himself acknowledges in paragraph 23 of his judgment in the Morrisons case, and as Lord Phillips noted in the Christian Brothers case at paragraphs 83 and 85, the close connection test has been applied differently in cases concerned with the sexual abuse of children, which cannot be regarded as something done by the employee while acting in the ordinary course of his employment. One of the practical explanations and justifications for this, I would suggest, is the grooming, which usually takes place as a precursor to child sexual abuse, and which is made possible by the employment or similar status of the wrongdoer, whether as a priest, teacher, a football coach, or otherwise. This is perhaps best explained in Maga in Birmingham Archdiocese, where Lord Justice Longmore cited with approval paragraph 6 of Mr. Justice Macklin's judgment in the Canadian case of Paisley. Because of the peculiar exercise of power and trust that pervade cases such as child abuse, special attention should be paid to the existence of a power or dependency relationship, which on its own often creates a considerable risk of wrongdoing. In paragraph 84 of his judgment in Maga, Justice Longmore went on, what is said in this present case is that while the church would accept responsibility for abuse of an altar boy and probably a member of the congregation, this case is different because the victim of Father Clonan's abuse came into his ambit in a non-church manner, by admiring his sporty Triumph car, by taking part in disco evenings, which all were welcome, clearing up afterwards, and then doing jobs in the presbytery. Father Clonan lived with Father McTurnan. But the progressive stages of intimacy were, to my mind, only possible because Father Clonan had the priestly status and authority, which meant that no one would question his being alone with the claimant. It is this that provides the close connection between the abuse and what Father Clonan was authorised to do. Maga shows how far the court will be prepared to stretch the close connection test to make a finding of vicarious liability in an appropriate case. Now I'm going to hand over to Chris and Freddie to talk about individual cases situations. I'm going to hand over first to Chris. Thank you.
Thanks, Nick. As Nick has set out, vicarious liability turns on the answer to two questions. The first concerns the relationship between the defendant and the tortfeasor. The second concerns the connection between that relationship and the wrongdoing. Again, as Nick has set out, the approach to the first question was recently considered by the Supreme Court in Barclays Bank, and the test is essentially this. Is the essence of the relationship between the defendant and the tortfeasor truly one akin to employment, or are the wrongdoers in truth independent contractors? In my part of this talk, I will explore how that test might apply to two different scenarios that are commonly encountered in practice. First, healthcare. Second, the building site. Turning to healthcare. Most clinical negligence claims will be against doctors and nurses who are employed by a defendant trust. In these cases, it will be uncontroversial that the defendant trust is vicariously liable for the acts of those doctors and nurses. However, increasingly, doctors and nurses provide their services through agreements other than traditional contracts of employment. In my own practice, I've seen this most often in the context of prison healthcare. For example, I acted for the claimant in a case called Musa and Care UK and ECPO, a case concerning alleged negligent medical treatment at HMP Belmarsh. At the time of the claimant's treatment, Care UK was contracted to provide healthcare services to HMP Belmarsh. In fulfilment of this obligation, Care UK had entered into contracts with doctors, including Dr. ECPO, and those contracts specifically stated that the doctor was not an employee, but an independent contractor. Vicarious liability in these cases is less straightforward, and particularly so following the decision in Barclays Bank. The reason for this is that Barclays Bank itself concerned the provision of healthcare. So a claimant asserting vicarious liability for the acts of a healthcare professional, who is purportedly a contractor, will need to distinguish his case from the facts of Barclays Bank. In order to distinguish our cases from Barclays Bank, we first need to identify the key factors that led to the result in that case. As Nick has said, Barclays Bank concerned assaults perpetrated by a Dr. Bates, who was undertaking examinations on behalf of the bank. Dr. Bates was held to be a contractor. In my view, there were 5 key factors that led the Supreme Court to this conclusion. The first factor is that Dr. Bates had a portfolio practice. This is described in paragraph 2 of the judgment on screen now as follows. Dr. Bates was a medical practitioner practicing in Newcastle upon Tyne. According to his son's evidence, he had a portfolio practice. Some of it was as an employee in local hospitals. Some of it was doing medical examinations for immigration purposes. Some of it was doing miscellaneous work for insurance companies, a mining company and a government board. Some of it was doing medical assessments and examinations of employees or prospective employees, originally for Martin's Bank, and later for Barclays Bank following their merger in 1969. This was, however, a comparatively minor part of his practice. He also wrote a newspaper column. The second key factor was that Dr. Bates provided his own facilities. This is described in paragraph 4 of the judgment on the next slide, which says, on the next slide, nope, yep, which says, examinations took place in Dr. Bates's home in Newcastle. A room in the house had been converted into a consulting room. The third factor relates to how Dr. Bates was paid. Firstly, he was paid on a per examination basis, and secondly, he wasn't paid a retainer. The fourth factor is that Dr. Bates was free to refuse to conduct an offered examination if he wished. The fifth and final factor is that Dr. Bates carried his own medical liability insurance. If we're looking to distinguish our cases from Barclays Bank, then we will need to consider each of those 5 factors and the extent to which they apply to our case. Extrapolating from the 5 factors, the questions which we might want to ask ourselves are as follows. Firstly, who does the tortfeasor work for? If the tortfeasor works only for the defendant or for very few clients, including the defendant, he's more likely to be an employee, If the tortfeasor has a portfolio practice like Dr. Bates, he's more likely to be a contractor. The second question is, who provides the facilities? And I use the term facilities in a broad sense here to mean locations, equipment, and even personnel. If the defendant provides all of the facilities, the tortfeasor is more likely to be an employee. If the tortfeasor provides all of the facilities, as Dr. Bates did, then he's more likely to be a contractor. The third question is, how was the tortfeasor paid? If the tortfeasor is paid for his time rather than for performing a task, then he's more likely to be an employee. If he's paid for performing a task, as Dr. Bates was, he's more likely to be a contractor. The fourth question is, what is the nature of the contractual relationship? And by this I mean, consider the specifics of the contractual relationship and identify any salient factors. In the case of Dr. Bates, the Supreme Court emphasised that he was able to refuse work that was offered. Some contracts, in contrast, will have minimum numbers of hours or an obligation to accept work when offered to maintain that contract. Where the tortfeasor has a stronger contractual obligation to the defendant, he will be more likely to be an employee. Where there is no contractual obligation or it is weaker, he'll be more likely to be a contractor. The final question is, who carried insurance for the acts of the tortfeasor? Where the defendant carried the insurance for the acts of the tortfeasor, he'll be more likely to be an employee. And when the tortfeasor carried his own insurance, he'll be more likely to be a contractor. Thinking about these 5 questions and how they might apply in the healthcare context, my view is that the outcome in Barclays Bank will be an outlier rather than the norm. In my own practice, I've already been asked to consider how Barclays Bank might apply to prison healthcare. And my view is that it would most likely be distinguished. Doctors and nurses in prisons tend to work solely for the prison, or to mix their prison work with work for a single GP's practice or for a single NHS trust. Doctors and nurses in prisons do not provide their own facilities. Treatment rooms, medical equipment, medicines and logistical support are provided by the prison or the body responsible for providing healthcare to the prison. Doctors and nurses in prisons, in my experience, are paid for their time rather than for each patient they see. They are also likely to be obliged to accept at least some work when offered in order to maintain their contracts. Of course, the outcome will depend on the specific facts of any given case. Turning now to my second example, the building site. This is a context where we see a whole range of working relationships. The answer to the question, is there vicarious liability, will turn on the specifics of those relationships. And again, I suggest that the relevant factors to consider are the 5 factors previously identified. In this table, I've taken 2 examples and sought to set out how the 5 factors might apply in each case. The examples are a specialist subcontractor, such as a plumber or an electrician, and a casual labourer. My analysis is on the screen. The point that I'm trying to convey from this table is that the question of vicarious liability will be fact specific, and that those 5 questions I've set out will assist you in your analysis of whether there is vicarious liability in any given case. That said, there are some types of relationships where there's more likely to be vicarious liability than others. And in the context of the building site, a defendant is more likely to be vicariously liable for the acts of a casual labourer than for a specialist subcontractor. I now hand over to Freddie, who's going to talk about the second question that governs the imposition of vicarious liability.
Thanks, Chris. I'm going to talk about how to apply the second stage of the test for the imposition of vicarious liability. Namely, was the wrongful act sufficiently closely connected to the employment or quasi-employment to justify the imposition of liability? And the first type of case I want to talk about are cases involving sexual abuse. In Morrisons, the Supreme Court confirmed that the close connection test is still applied differently in cases concerning the sexual abuse of children. So, rather than focusing on the question of whether the wrongful act happened during the ordinary course of employment, the courts focused instead on criteria that are specific to the commission of sexual abuse, such as the employer's conferral of authority on the employee over the victims. creation of risk is not enough in and of itself to give rise to vicarious liability for abuse, but the courts held in the Christian Brothers case that it is likely to be an important element in the facts that give rise to such liability. So what are some of the relevant factors in deciding whether vicarious liability might be imposed? First, the opportunity that the enterprise afforded the employee to abuse their power. Did the enterprise allow employees to spend time without children unsupervised? Were victims practically able to report the abuse? Secondly, the extent to which the wrongful act may have furthered the employer's aims and hence be more likely to have been committed by the employee. Third factor, the extent to which the wrongful act was related to intimacy inherent in the employer's enterprise. Fourthly, the extent of the power conferred on the employee in relation to the victim. Was there an asymmetry in the power dynamic? Was the employee's power open to challenge by the victim? Lastly, the vulnerability of potential victims to the wrongful exercise of the employer's power. It's worth looking briefly at a few of the major cases here. In Lister and Hesley Hall, that case concerned sexual abuse of children by the warden of a schoolhouse, and vicarious liability was imposed because the actions of the warden were inextricably interwoven with his duties so that it was just to hold the employer liable. Factors the court considered to be relevant in that case were, firstly, the close contact with children, secondly, the warden's unrestricted access to the premises, thirdly, general authority in the supervision and running of the house, and fourthly, the warden's position of trust. In the Christian Brothers case, which concerned abuse of children by teachers at a residential school, again, the close connection test was made out. And Lord Phillips stressed the following, that the victims were triply vulnerable because they were children, they were virtually prisoners in a residential school, and their personal histories made it extremely hard for them to disclose information about the abuse. So in that case, the fact that the abuse was diametrically opposed to the school's objectives of caring for the educational and spiritual needs of the children was, in the court's words, one of the factors that provided the necessary close connection between the abuse and the relationship between the brothers and the institute to justify the imposition of vicarious liability. In Maga, a priest sexually abused a child over a number of years, and the close connection test was again satisfied. And the court did a detailed analysis of those factors. Firstly, they noted the importance of appearances, the fact that the priest was normally dressed in clerical garb and was when he first met the victim. In the words of the court, this set the scene for what followed. Secondly, the moral authority of the priest, who had a special role which involved trust and responsibility in a more general way even than a teacher, a doctor, or a nurse. Next, evangelization. The priest used their evangelizing duty as a pretext to get to know the victim. The victim's age. The victim was only 12 or 13 when they met the priest. Fifthly, the youth work. The priest was given a special responsibility for youth work, and therefore in carrying out the grooming, the priest was ostensibly carrying out one of their specifically assigned functions within the church. Lastly, opportunity, because the priest developed the relationship by inviting the victim to a disco on the church's premises and organized by the priest. So the takeaways from the Maga case are twofold. Firstly, it shows the importance of investigating the employee's specific duties and determining whether they give rise to special opportunities for wrongdoing. Check the contract. What does it allow the employee to do? Secondly, special attention should be given to the existence of a power relationship or a dependency relationship, which itself gives rise to a considerable risk of wrongdoing. Briefly, I want to talk about a couple of other scenarios. What happens if abuse is committed by a gardener at a boarding school? In my view, probably the gardener would not be, the employee would not be vicariously liable if the gardener had nothing to do with children, or was not meant to have had anything to do with the children. Secondly, what about a case where a tour guide on a school trip commits abuse Again, that depends on the nature of the relationship, the supervision of their activities, how much power was conferred. I now want to discuss cases of wrongful conduct in and around the workplace. And the courts have attempted to separate these cases broadly into two types of case. Firstly, cases in which the use of reasonable force or the existence of friction was inherent in the nature of the employment. Those cases normally give rise to liability. Secondly, cases such as those arising from intentional acts at the workplace, whether horseplay or more serious conduct, which do not usually give rise to liability. So, two subgroups here. Firstly, work-related social events. Here are some of the factors that might be relevant in this context. Is the employer paying for or organising the event? Does the employer benefit from the employee's attendance? Is attendance expected or requested? Is the wrongful act a product of or related to the workplace culture? Is the wrongful act related to the work itself? And the answers to these sorts of questions will give a steer as to where the vicarious liability would be imposed. The Court of Appeal has recently considered this context in the case of Bellman against Northampton Recruitment, and that case was expressly approved in Morrisons by the Supreme Court. So in Bellman was an employee of a company run by a managing director. The managing director arranged a Christmas party and an informal after party. And at the after party, the managing director berated the company's employees about the employment policy. The claimant challenged the managing director about what he was saying. And the managing director's response was to say he was in charge, and he followed that up with a punch to the claimant's face. And the court ruled that when he committed the assault, the managing director, he was purporting to act as the managing director and was asserting his authority in front of members of staff over a subordinate employee who had challenged his managerial decision-making. Importantly, the assault in Bellman occurred outside working hours and away from the workplace. And still, the court found a very close connection between authorized activities and the assault. At the same time, in a concurring judgment, Lord Justice Irwin stressed that this was an exceptional case and that liability would not automatically arise whenever there's an argument between colleagues at a Christmas party. Contrast Bellman with the recent High Court decision in Shelbourne, in which the claimant was physically lifted up and dropped when on the dance floor at the Christmas party, sustaining a spinal injury. She claimed that her employer was vicariously liable. The court ruled that the employer was not vicariously liable because the employer's the assaulter's field of work was confined to his research work for the defendant. And the court stressed a few factors such as that his attendance at the party was not compulsory, his work had ended hours previously, and that his professional duties were unrelated to the wrongful act. Notably, all of those factors are present in Bellman, in which the Court of Appeal found that there was a sufficiently close connection to impose vicarious liability. In Shelbourne, the court distinguished Bellman rather briefly on the grounds that the assaulter had no real authority within the company. I want to consider briefly a case study which has been reported in some of the papers. This concerns a Premiership rugby club, Saracens, who have been sued by a former rugby player who alleged that he was hit on the head with a fire extinguisher during the club's trip to Hungary, causing the player to suffer a career-ending concussion. Now, factors that might be relevant here might be, did the club play a role in organising the squad outing? What was the culture of the rugby club? Was there a history of players playing practical jokes on each other? Were those incidents celebrated? Who paid for the trip? And what was the stated purpose of the trip? And the question will be whether this behaviour would be treated as deliberate stupidity beyond the ordinary rugby club culture, as in this case of Graham against Commercial Bodyworks, in which the employees sprayed the co-workers' overalls with inflammable substance, which was also used for their work, and the employee then set fire to his co-workers' overalls. And the court held that the employer was not vicariously liable, even though they had required employees to work with an inherently dangerous substance, and the court considered that it was an intentional act outside the course of the employment. Next, I want to talk about assault cases. Factors, slightly different assortment of factors would be relevant in establishing the close connection test here. Questions such as, was the violence integral or incidental to the work? Was the violence to the benefit of the employer? Did violence happen on the premises? Did it happen during working hours? Was there a friction inherent or incidental in the employer's business? Brief look at some of the cases then. So in Mohammed, which Nick has talked about, the employer was vicariously liable for assault by the petrol station attendant. There was seen to be a connection between his job responding to inquiries and the escalating series of events that followed. In Granville and Carroll, there were two cases now where violence was found to be inherent in the employment. The first being this case of Granville and Carroll on screen, in which a punch was thrown by the defendant rugby club's player in the altercation that followed the final whistle of a rugby match. It was held that this was a sufficiently ordinary incident of a rugby match to engage the defendant's vicarious liability. The court pointed to the fact that this behaviour was tolerated as part of the claimant's employment. Secondly, the case of Mattis and Pollock. The defendant nightclub employed an unlicensed doorman to maintain order at the club. One night he got in a fight with a man at the club and ended up stabbing him later that evening. And the nightclub was held to be vicariously liable, even though this was seen to be a clear act of revenge. Factors that the court stressed in that case included the fact that the doorman was encouraged by his employer to act in an aggressive and intimidating manner towards customers. Secondly, that the incident took place within working hours. And thirdly, that it was clear that the bouncer would have been violent whether inside or outside the premises. Lastly, two brief court of appeal cases, which I want to look at, which give some guidance about where to draw the line in assault cases. So, in the case of Weddell against Barchester Healthcare, Weddell was the deputy manager of a care home for mental health patients operated by the defendant. He called an employee one evening, a healthcare assistant, to ask him to cover a night shift. The employee was drunk at the time and thought that when Weddell called him, he was actually mocking him. The employee then cycled to the home and attacked Weddell. And the court held that the assault was an independent venture of the employee, because the instruction or request to cover the night shift was no more than a pretext for an act of violence unconnected with his work as a health assistant. By contrast, in Weddell against Barchester Healthcare, the employee, in Wallbank against Wallbank Fox Designs, ignore the heading there, Wallbank was employed by the defendant manufacturing company. He spoke to an employee about shortcomings in his work and went to assist him. And the employee assaulted him when they got there. And the court found that the risk of an over robust reaction to an instruction was a risk that was incidentally created by the employment. So what we can see there is that these cases, the fundamental message is that these cases are very fact specific. And then we've tried as far as possible to identify factors which will steer you as to whether that close connection test is satisfied. And with that, I'll hand over to Nick to conclude and respond to questions.
Thank you, Freddie. I'm sort of slightly conscious that we've gone a little over time, and it's such a beautiful and hot and sunny afternoon. So although we've had a number of questions, I'm just going to answer one of them, and then allow you to get back, hopefully, to your gardens. The question is do you think the close connection still has a place in establishing liability in employee stress at work or bullying type cases? And the short answer to that is yes, it does have a place. It's fundamental in establishing the vicarious liability of the employer, and in most cases it will be satisfied. it's only likely to be in very extreme, there's been one very extreme and isolated act of bullying where it would not apply, vicarious liability would not be established in practice. And I think the Bellman case, which Freddie has just referred to, shows that that in the circumstances that you would envisage in a normal stress at work or bullying type case, the close connection factor would clearly be satisfied. Now, can I thank everyone for taking part in this week's webinar, and can I just finally hope and invite you to join us in next week's Doughty Street PI Clinic Team webinar, where Theo Huckle, Chris and Freddie again will be talking this time about employers' liability. But thank you very much again, and enjoy the afternoon. I should say we'll get back to the other questioners individually by email. Have a very good afternoon.